Effective April 11, 2025, all non-citizens in the U.S. must comply with the alien registration obligation. And this is a new thing under the Trump administration where they put a deadline to when you need to register. Whereas before there was a registration requirement, but previous administrations were not really enforcing it. This administration is saying you must register or there will be consequences. Let's talk about who is already registered, who is not registered, who must register, and what evidence constitutes proof of registration, right? We want to go through these because there's some people that will call me and they're like, oh my goodness, do I need to register? Am I under this obligation? And half of the time, they are already registered and they just don't know it. So let's talk about what registration looks like and who needs to register, whether you're already registered, how you can tell if you are already registered. I am U.S. immigration attorney Lilian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system, whatever it looks like that day. We are going to start with who is already registered, okay? Non-citizens need to register if they've been in the U.S. for more than 30 days. But you want to know, am I already registered? Let's talk about it. If you are a permanent resident, honey, you are already registered, okay? Let's make that very clear. Permanent residents, whether it's a 2-year or a 10-year, you are already registered. Your permanent resident card is your proof of registration, right? But we're going to go even deeper and talk about what type of forms are considered applications for registration. So not every single thing you file with USCIS equals registration. So let's talk about which forms, if you have it or have had it, equals registration. The first one is an I-67, which is an inspection record for Hungarian refugees. The next one is an I-94. It's an arrival and departure record. Anytime you're coming into the U.S., whether with parole or with a visa, you are getting an I-94. Next one is an I-95. This is typically for crew members, landing permit. So you would have an I-95, not an I-94. An I-181, an I-485, that's the green card application, an I-590, that's the classifying someone as a refugee, the I-687 application for status as a temporary resident, okay, not TPS, a temporary resident, Form I-691, Form I-698, Form I-700, Form I-817, and Form G325R. So the G235R is the registration information. That's the form that you would fill out if you are not already registered. So it's really important that you know if you have filed any one of these forms, okay? If you have filed any one of these forms and you have provided biometrics, you have went for your fingerprints, then it is considered registration. It doesn't matter if any of these forms are approved. It matters that you filed it and you did biometrics for it. That is your proof of registration, okay? Another group of people that are already registered are people that applied for a visa and entered the U.S. The last time they entered the U.S. was on that visa. Those people are already registered, okay? It doesn't matter if you overstayed your visa. It doesn't matter if your I-95 or I-94, in this case, is already expired. You want to make sure that the last time you entered was on that visa. Not that you applied for a visa before and that visa was, approved, but you never traveled to the U.S. on it, or you traveled to the U.S. on it, but you went back home, and then the next time you came in was not with a visa. If you're in that situation, let me tell you, you are not registered because the last time you entered the US was not on that visa. If you entered the US with humanitarian parole, military parole in place, any of those types of paroles, you are considered registered. Okay, so if you came in with humanitarian parole, you are already registered. Your I-94, remember you have that. Your I-94 is your proof of registration. So that's why I said, when you have an I-94, you are already registered. Because in order to get that I-94, the US government has to register you and have fingerprints done. Okay, so if you came in with parole and you were fingerprinted and you were given that I-94, you are already registered. Okay, and your I-94 is your proof of registration. Now, who is not registered? Okay, this is another important thing. Non-citizens who have not registered include non-citizens who entered the US without inspection and admission, meaning you came in without ever having any interaction with US immigration, not at the airport, not at the border. You came in, you didn't have any interaction, and you're in the US. Okay, you did not have parole. Canadian visitors who entered without documentation are not registered. Non-citizens who submitted applications not considered as registration. So for example, if you are a DACA recipient, you are not considered registered just because you have DACA. However, if you have a work permit under that DACA and that work permit is still valid, you are considered registered. Same thing for TPS. TPS in of itself is not registration. However, if you have a work permit under that TPS, you are considered registered. So it is really important that just because you file a form and you may have been fingerprinted for that form does not mean that you are registered. Same thing for an I-601A waiver. If you filed an I-601A waiver and you're still waiting for that to be approved and you have never came into the US with any sort of parole, any sort of visa, you never had an I-94, you never had any of the forms that I mentioned earlier, you unfortunately are not registered. If you happen to be under DACA and you had employment authorization and now you're filing for your 601A waiver, that's fine, right? Because you have that employment authorization, that counts as registration. The 601A waiver that you filed, even though you did fingerprinting for it, does not count as registration, okay? Now, who must register? If you are 14 years old or older and we're not registered or fingerprinted upon visa issuance. So for people that are under the age of 14, children that are under the age of 14 are not typically fingerprinted when they are given a visa to the US. Because of that, even though they had a visa to the US, they are not considered registered because they never had the fingerprinting done. So they would still need to get registered. Now, if they are not in the US for a long period of time, meaning 30 days or more, they do not have to register. Okay, so if you're 14 years old or older, you were not fingerprinted when you got your visa, okay? And you stayed in the US for 30 days or more, you need to register. Really important. So it's really important for children that are, that were under the age of 14 when they got their visa and then now they're in the US and they are over the age of 14, they will need to register because they were never fingerprinted. That's really the key for registration. It's not only to get all this information about you, but to get your biometrics. So that's why the forms that I mentioned require biometrics as part of that process. And you get some form of documentation from USCIS as proof of your registration. Okay, so really important. If a child is a lawful permanent resident. Like I said, permanent residents do not need to register unless the child was under the age of 14 when they got their residency. Then they must register. Okay, remember, children under the age of 14 do not have to go through biometrics. All right, so it also would apply for lawful permanent resident children that are under the age of 14. They will need to register because they never got biometrics. So first step in registration is to set up a USCIS online account. This is a must. There's no way around them. The second step is to submit the form G325R through your account. Okay, this form cannot be mailed in. You cannot print it out, fill it out, and mail it into USCIS. You can only do this by creating a USCIS online account. Again, this is creating barriers for people, but that's what this administration likes to do. Once you submit that, then you'll be scheduled for biometrics. You'll have to go in and get fingerprinted and have your picture taken. Then after that, USCIS will send you proof of your registration, and you have to carry that proof of registration with you at all times if you are 18 years old or older. All right, so that's what you have to do. If you have consulted with an attorney and have made the decision to register, that's what you need to do to get registered. And then if you are considering not registering, let's talk about the consequences that may apply if you choose not to register. So just for not registering, they can fine you up to $5,000 or put you in jail for up to 6 months. Okay? If you are registered and you do not carry proof of your registration with you, you can be punished by a fine of up to $5,000 and or imprisonment up to 30 days. Just for not carrying the proof. You registered, but you don't have the proof on you, they can fine you up to $5,000 or put you in jail for up to 30 days. And then if you fail to update your address with USCIS, again, non-citizens are supposed to update their address within 10 days of moving. They're now saying if you do not update your address within that 10 days, it can be punished by a fine of up to $5,000 or imprisonment up to 30 days and may result in deportation. Okay, so they are really, really trying to scare people and put a lot of penalties in place to force people to go ahead and register. Now, submission of false information will be punished by criminal penalties and possible deportation. So, if you choose to fill out the registration and submit the registration, you have to make sure, like I always say, make sure you're putting accurate information on your forms that you're sending to USCIS, because lying on that can have more consequences than not. Okay, so you want to make sure if you are going to go ahead and file the registration that you are being honest on that form. Now that we know all of that, right, the penalties that can apply, let's talk about your rights. Okay, so when it comes to the G325R, there are questions on there that are yes or no questions that can be incriminating. Right? Remember, if you're in the US, you have the Fifth Amendment right against self-incrimination. Okay, you have that right. But with the way this form is set up, you are basically saying yes or no to questions that you may not even be fully aware of what you're saying yes or no to. And you may not know that saying yes to certain questions can lead to criminal consequences, can lead to deportation consequences. So you really want to, again, make sure that you are taking steps to protect yourself. Part of the form G325R requires information about, if you have any unlawful entry, immigration violation, criminal activity. If answering those questions will mean admitting unlawful entry, immigration violations, criminal activity, you have a right under the Fifth Amendment of the United States Constitution to refuse to answer those questions. But remember, again, why you should be consulting with an immigration lawyer and possibly a criminal defense attorney before registering is that you do have this constitutional right, and you cannot be forced to make statements that could be used against you in a criminal case. Okay, so just be careful about that and know that you do have those rights, because USCIS requires all questions to be answered on that form before you can submit it. You cannot skip those questions. Again, why I started at the beginning by saying get a criminal defense attorney to review your situation, at least as far as the criminal case potentially incriminating yourself. Okay, now, because I don't represent you, I don't know anything about your case, I cannot tell you whether you should register or not. That's really for an attorney that has had full, view of your situation to give you a specific how would this apply to you consultation. Okay, that's not something I can do in these videos. I can give you general information. Now, here's the consequences for not registering. Okay, that's something a lot of people have asked me, is what happens if I choose to not register, right? We know that not registering has, criminal consequences. You can end up in jail. You can have the $5,000 fines. But also, if you apply for immigration benefit in the future and have not registered, the Department of Homeland Security may use your failure to register as a negative factor on your application. So it's not saying that they will deny your application just because you did not register, but they can use that as a reason to deny your application. So it's not automatic, but they can use that as a negative factor in determining whether to approve your case or not. Now, if you choose not to register and the government can prove that you did it willfully, meaning that you intentionally decided not to register, you may be charged with a misdemeanor offense, and this could result in a fine of up to $5,000 and or imprisonment for up to 6 months. So it's really, right, it's all encompassing when it comes to this registration and what the administration is trying to do. There's criminal consequences to not registering if they can show that it was willful, meaning that you intentionally decided not to register. In those situations, they can bring a criminal charge against you, which can then lead to $5,000 in fine or and or up to 6 months in jail. So again, this is not something to be taken lightly. This is something to really have a detailed conversation about. Really, if you've had any criminal history or things like that, getting consultations with a criminal defense attorney. All right. So on the immigration lawyer end, honestly, when it comes to this, we are not, because of our ethical obligations, I am not doing this for my clients. I am giving them the information. It's up to them to take the steps to register if they choose to register, okay? Because of these questions that require basically a client to self-incriminate, right? I can't advise a client to self-incriminate, and I cannot help a client to do that because of my ethical obligations under the law. Right. Us lawyers are covered under ethics. We can advise, we can answer questions. However, we are not able to really do this for you. So that's why I say you need to get that consultation, know your rights, know what you are able to do, know why you're answering yes or no to each question. Right? If you think there may be things on there that can be self-incriminating, like unlawful entry, immigration violations, criminal activity, make sure that you are getting consultations with a criminal defense attorney as well, to protect you as much as possible. If you are in the process of applying for a green card, or you are still thinking about applying for a green card, remember, green card holders are exempt from this because you're already registered. And if you already filed your green card application and you have been fingerprinted, you no longer have to worry about this either. So it is twofold, and you want to make sure that if you are in the process of applying for a green card, that you do that, because that can equal registration for you. And if you need help with your green card, feel free to reach out to me. We can schedule a strategy session to find out the best way for you to move forward and how we can help you do that. You can schedule that consultation with me by going to my website, lilylegal.com, and clicking on Contact Us, where you can choose a date and time that works best for you for us to chat about your case.